Good evening, everybody. Thank you. Welcome to the Herbert Family University Lecture Series, brought to you through a generous gift from Helen and Jeff Herbert. Thank you and your entire family for making this evening possible. My name is Dr. Rich Reddick, and I'm the Senior Vice Provost for Curriculum and Enrollment and the Dean of the Undergraduate College here at UT Austin. I'm also a longtime professor in the College of Education, the African and African Diaspora Studies Department, and this semester, I'm also teaching a signature course, or as you might know them, a UGS course called Black Austin Matters. Anybody in the crowd? Any of my people? All right, I see you. Yeah, thank you. With Dr. Lisa B. Thompson. I have personally presented at this lecture series last fall, and I can tell you that it was an incredible experience. So I am sincerely excited to be here this evening. And speaking of this evening, please join me in giving a round of applause to welcome our speakers for tonight's lecture, The State of Affirmative Action. I assure you that what you have prepared for you will be equally engaging and enlightening. Big hand for our speakers. Now, I will introduce each speaker before the lecture, but first, some quick housekeeping. Hopefully, you have scanned the QR code that you've been seeing on the slides rotating behind us. We'd love for you to send questions in that you have during the lecture. Once our third speaker has finished, we ask you to remain seated for 5 to 10 minutes for question and answers that will conclude the evening. Please do not get up out of your seats until the Q&A is finished. And so, our first speaker tonight is Dr. Peniel Joseph. Dr. Joseph holds a joint professorship appointment at the LBJ School of Public Affairs in the History Department in the College of Liberal Arts at the University of Texas at Austin. He is also the founding director of the LBJ School's Center for the Study of Race and Democracy, an inaugural associate dean for Justice, Equity, Diversity, and Inclusion, and the Barbara Jordan Chair in Ethics and Political Values. His career focus has been on Black Power studies, which encompasses interdisciplinary fields such as Africana studies, law and society, women's and ethnic studies, and political science. Again, it is my pleasure to welcome you to this event. At this time, I'll turn it over to my colleague, Dr. Peniel Joseph.
All right, thank you. I'm just back from Accra, Ghana. Does anybody know where Ghana is? All right, West Africa, the motherland. So I'm just back, extraordinary trip, both for research and my own personal development. But what I want to share with you in the time that I have, very short amount of time, is just to talk about a story about affirmative action in 3 phases. We think about affirmative action as something that just started in the 1960s or 1970s. But this idea of affirmative action has deeper roots than just policy. Affirmative action is based and rooted in the origin story of the United States of America. And that origin story is the story of racial slavery existing alongside of a rhetoric and a politics of democracy and freedom. And when we think about affirmative action is connected to 3 periods of Reconstruction in American history. The first period of Reconstruction is 1865 to 1898. The second period of Reconstruction is 1954 to 1968. And the third period of Reconstruction is 2008 to the present. And really, throughout these 3 periods of Reconstruction, we've had a debate over how do we achieve dignity, citizenship, and democracy for all Americans. On one side of the debate has been Reconstructionists. And Reconstructionists are believers in multiracial democracy. These are folks who thought in the aftermath of the Civil War, we needed citizenship and dignity for Black people, but by gaining citizenship and dignity for Black people, all Americans, including women of all colors and backgrounds, would have the right to vote and have citizenship and dignity and freedom. They were opposed by redemptionists, and redemptionists were people who believed in the lost cause. They believed in a vision of racial exclusion, a vision of white supremacy, but also a vision of gender exclusion and religious exclusion, class exclusion, hierarchies. And when we think about these three periods of Reconstruction, even though we don't call things like the 13th and the 14th and the 15th Amendments affirmative action, that's what they actually are. Because affirmative action is about both ending structures and systems of white supremacy, but it's also about a political and moral reckoning, right, with racial slavery and what happened. I just was in Ghana, I was in Accra, but I was also in Cape Coast, and I saw 3 different dungeons, one at Elmina, one at Cape Coast, and one at Osu Castle in Accra, and went through all these different dungeons where enslaved people in the 15th, 16th, 17th, 18th centuries were placed, doors and gates of no return, and that slave trade enriched the entirety of the globe except for the people who were enslaved, right? So when we think about the 13th Amendment, the ending or the abolishing of racial slavery except in instances of punishment. The 14th Amendment, which is citizenship rights for all people, birthright citizenship. The 15th Amendment, which is voting rights for black males, but there were advocates and reconstructionists like Frederick Douglass and like so many different other people, Frances Harper and different black women who wanted black women to vote as well. The Freedmen's Bureau is set up during this first Reconstruction, and that's supposed to help formerly enslaved African-American men, women, children get land, have fair wage or labor contracts, get health care, education. There were people who said that that was reverse discrimination right after racial slavery. We had a war, a civil war for 4 years, 1861 to 1865. Over 700,000 Americans died, but some people felt that having a Freedmen's Bureau and having any kind of policy or legislation that was going to lead us to truth, justice, and reconciliation was reverse racism. They argued for colorblindness, right? A colorblind philosophy. But that colorblindness too often was going to lead to the same outcomes for which the Civil War was actually fought. Let's go to part 2, the second Reconstruction, 1954 to 1968. Sometimes we think of this period as the heroic period of the Civil Rights Movement. The Brown v. Board of Education Supreme Court Justice decision says that public school segregation is unconstitutional. But there's really no rigorous enforcement. Within 10 years of that decision, maybe about 7% of American schools are racially integrated. John F. Kennedy in 1961 passes an executive order calling for affirmative action in the building trades and federal contracts and employment. By 1965, Lyndon Baines Johnson, and we have the LBJ school here, right here on campus in the library, he signs a different executive order that supersedes Kennedy's and actually calls for even more robust hiring. And he uses that term affirmative action. LBJ is really important here because Lyndon Johnson, as president, does this commencement address at Howard University in 1965 on June 4th, where he says that he doesn't just want equality of opportunity. He argues, this is the President of the United States, and it's really extraordinary based on where we're at today. He argues for equality of outcomes. What Johnson does is tell a story. He says we can't have 2 runners and one runner has been shackled for centuries by racial oppression and slavery and remove the shackles and tell them to race the other runner who has not been shackled. That's not going to be fair. But even during this second period of Reconstruction, this is the age of Rosa Parks, the death of Emmett Till on August 28, 1955, Little Rock, Arkansas in 1957, and the school desegregation crisis. And if you Google Little Rock, Arkansas right now, you'll see the Norman Rockwell painting and the small little black girls who are really attacked by mobs of whites outside the school when they're just trying to go to Little Rock Central High School. 1960 is the Student Nonviolent Coordinating Committee and the sit-ins at the Woolworth's lunch counter, which is now a civil rights museum in Greensboro, North Carolina. Even during the period of Martin Luther King Jr. and the I Have a Dream speech, which we just celebrated the 60th anniversary of, folks said that affirmative action, or trying to look for truth, justice, and reconciliation, this idea of a moral reckoning, this idea of reparations, affirmative action for that history of racial slavery and segregation and white supremacy and violence and lynching, they said that was reverse racism and reverse discrimination. So this is before the Bakke decision. This is before the UT decision. This is before what just happened, which we're going to get into. Now I want to get into the third Reconstruction, 2008 to the present. What's so interesting about the idea of affirmative action in this third Reconstruction is that the last 14, 15 years of American history, we've seen 4 pivot points, 4 hinge points, I argue. One is the election of Barack Obama in 2008. 2 is the rise of Black Lives Matter. 1.0 in 2013 after the murder of Trayvon Martin. And what goes along in 2013 is also the Shelby v. Holder decision, 5-4, that ends the Voting Rights Act and really ends the racial justice consensus that existed between 1963 and 2013. 3 is the election of Donald Trump and the Make America Great Again movement in 2016. And then 4 is 2020 and all of the different racial and political reckonings and juxtapositions that have come since then. Both when we think about George Floyd and people said they wanted to be allies, people said it was time for a political and moral reckoning. People were actually speaking in the language of affirmative action, but not affirmative action from the 1960s, affirmative action from the 1860s and the 1870s during the period of Reconstruction, where people argued that America, and Abraham Lincoln said this at Gettysburg in 1863, that a new birth of freedom had been inaugurated and inspired by the Civil War at Gettysburg, right? That's what Lincoln said, right? And during Lincoln's second inauguration in 1865, he says that if America has to give back every piece of wealth that was procured through the drops of blood by what he called the bondsmen and the bondswomen, then people shall say the judgment of the Lord is just and merciful, right? That's Abraham Lincoln, right? So in the aftermath of George Floyd, what we've seen, instead of that moral and political reckoning that everybody said, we even had Roger Goodell of the NFL, the folks who had marginalized Colin Kaepernick for speaking out against racism and white supremacy, saying Black Lives Matter. Everybody was saying it in 2020. What we've seen in the last 2.5 years is not an unprecedented white backlash. It is precedented. It's the third period of Reconstruction. We've seen this backlash from jump. And this backlash now continues what's happened during the first 2 periods of Reconstruction. Even Klansmen in the 1860s and 1870s said they were not racist. The Ku Klux Klan, white supremacists, said they were not racist. We had our first Klan hearings in the United States of America in May 1871, congressional hearings where hundreds of people testified about what the Klan had been doing to black folks in the South, including places like Texas, right? So this idea of colorblindness versus affirmative action. I have 1 minute and 19 seconds. Colorblindness is the story of redemption. It's the story of the lost cause. It's the story that says white supremacy is something that is good and normative, and we are a white, God-fearing Christian country that has enslaved these black people, and that was a good thing. And we're going to continue to perpetuate that lie, and we're going to call anything else critical race theory. We're going to call anything else communism. We're going to call anything else anti-American, right? Versus the story of Reconstruction, which wants truth, justice, and reconciliation. To tell the truth, we have to end the lie of American exceptionalism, and American exceptionalism is based on this idea that black people were not human beings, which is how you could justify racial slavery and get away with it for all time and never think about reparations, right? The justice is the policies. It's not just legal and legislative policies. We need a moral reckoning, which is what Dr. King called for at the March on Washington. He ended that speech by talking about having a dream, but he began that speech by saying now is the time to make real the promise of democracy. And so when we think about affirmative action, We have to make real the policy of democracy by telling no lies, claiming no easy victories, and thinking about the moral reckoning that we actually need to end this national nightmare. Thank you.
That is my colleague, Dr. Peniel Joseph. Our second speaker is Professor Lisa Eskow. She is a clinical professor at UT Law and the co-director of the Supreme Court Clinic. Lisa joined the UT Law faculty in 2014 after 18 years as an appellate specialist in private practice and public service. She has argued in the U.S. Supreme Court, Texas Supreme Court, and federal and state courts of appeals nationwide. Thank you for being here tonight, Professor Eskow.
Thank you so much, Dean Reddick, and it is amazing to be here on the stage. I have to say it's a little humbling, but I'm honored, I'm thrilled to be here, and I want to talk to you tonight about the decision last year in the U.S. Supreme Court that held that the Harvard and UNC admission policies violated equal protection. So, I don't know if folks have ever visited the Supreme Court. It can be sort of an imposing place, an imposing idea, an imposing concept, but I want to encourage you to start thinking about the institution as just 9 people. 9 smart people, 9 people you may disagree with or agree with, or sometimes a little of each, and people who have opinions about the cases before them, and they combine in different groupings to make law. But I want you to keep in mind that they are just people, and I'm going to try tonight to demystify maybe the process of Supreme Court litigation and what happens at the court, because as you embark on your college careers, I want you to start watching what they're doing, because they work for you. And you have an opportunity to pay attention and learn about what's happening at the court. So the first pitch I'm going to make is to go check out the U.S. Supreme Court's website. You can pull the opinions that they write. You can listen in real time, live, to oral arguments that are happening at the court. You can pull the briefs and the filings that parties make. So there's actually a surprising amount of transparency at the court in terms of the goings on and your access to it, even remotely. There's also a ton of commentary out there about the court. Some of it is podcasts, some of it is blogs. Some is on the right, some is on the left, but you can find the voices that resonate with you. Hopefully check out some of the voices you don't like, just to broaden your perspectives. But I encourage you to look at what the court's doing and also to listen what people are writing about the court. So let's turn to the decision itself. There were 2 lawsuits filed by a group called the Students for Fair Admissions. They challenged the admissions policies at Harvard and the University of North Carolina, saying that they both impermissibly used race to make their decisions of who to admit. And in a 6-3 decision written by Chief Justice John Roberts, the court held that those admissions policies violated equal protection principles under the 14th Amendment, one of the Reconstruction amendments that you just heard about from Dr. Joseph. And those same principles also applied to Title VI, which is a federal statute that governs private institutions like Harvard. So slightly different lawsuits, slightly different laws, slightly different admissions programs, but the court bundles them all together and invalidates them in one opinion. I made a pitch to you to start thinking about the court as people, and this is the people view of that 6-3 decision. So you see the chief over there on the left side of the screen, Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, and Justice Barrett. Those were the 6 people who all signed on to the majority opinion. Then you have separate writings, the 3 justices who are on the left side going down. Justice Thomas, Justice Gorsuch, and Justice Kavanaugh all joined the main opinion, but then also wrote separately to give a little bit more perspective on how they think and why they joined that majority opinion. On the right side of the screen, you have the 3 dissenters, Justices Sotomayor, Kagan, and Jackson. I like that picture of all 3 of them together. It makes me happy, so I have them all 3 together there for you. And Justice Sotomayor wrote separately in what is the principal dissent is the label, and then Justice Jackson has a separate dissent that is just in the UNC case because she recused herself from the Harvard case, having formerly been on the board of overseers that helped the university make strategic decisions. So just an abundance of caution, she only participates in the UNC case, but again, the court bundles it all together and decides them as one. I'll talk a little bit about a dialogue that happens between Chief Justice Roberts and Justice Sotomayor, specifically on Brown v. Board of Education and the end of the separate but equal doctrine, and this notion of colorblindness, again, that you heard about from Dr. Joseph, and what that role is, whether that is what the 14th Amendment and the Equal Protection Clause is supposed to be about, or whether it's about something else. You also have a dialogue going on here in these opinions between Justice Thomas and Justice Jackson about the origins of the 14th Amendment, about originalism, and also about the enduring effects of the legacy of racial inequality in the country and whether race is still relevant as a consideration in society that affects people's lives, or whether that's just a thing of the past, and they have very different views on this. So, what came before this decision? You heard Dr. Joseph mention Brown versus Board of Education, right? So that's the seminal decision that ends separate but equal. The Bakke decision involved UC Davis and their medical school, which used to reserve a certain number of spots. So it had a quota for black applicants. And the court in Bakke determined that that kind of a quota was impermissible. But 5 justices on the court, for varying reasons, so they don't all agree on the rationale, but 5 people said you can consider race in admissions in higher education. That's totally valid. And one of the rationales that was put forward in what has become the lead opinion from that case talked about the educational benefits of diversity. And the lower courts seized on to that, and as courts progressed through the Supreme Court and the lower courts, that notion of the educational benefits of diversity was embraced as a compelling interest to permit the consideration of race in the admissions process, as long as it's done in a very limited and specific way. So you see 2 cases out of the University of Michigan, one from the undergrad program, one from the law school. The undergraduate admissions program had awarded certain points for race, and that was determined to be invalid. But the law school just used race as a factor to achieve these benefits of diversity, and that was determined to be okay. But the court said in that opinion, there's going to be a time clock, essentially. You can't go on forever using race in admissions decisions, and we think 25 years sounds like a good amount of time. So those decisions happened in 2003. 25 years brings you to 2028, and we don't get that far because you have the Harvard and UNC decisions happening in 2023. Before that, though, you do have 2 cases that go to the US Supreme Court out of the University of Texas, and what was then the top 10% plan that took admitted students from the top 10% of high schools and then filled the remaining seats by using race as a consideration. The Supreme Court upheld them, but not the same when they got to Harvard and University of North Carolina last year. Okay, what about this clash between Justice Sotomayor and the Chief on Brown versus Board of Education? What's that issue there? It depends, who you ask as to what Brown versus Board of Education meant and why it's important. To the Chief, it signified that the time for making distinctions based on race has passed, right? So Brown versus Board of Education gets decided, it's all good. No need to ever consider race again. Justice Sotomayor says Brown was about the importance of education in our society and the need to be race conscious in ensuring access to from all people applying for access to education. The Chief in Brown takes pieces of oral arguments by the advocates in Brown versus Board of Education, pieces of briefs, pieces of the opinion, puts it together and highlights this notion that you heard about from Dr. Joseph, that the Constitution is colorblind. That is the theme of the majority opinion. Justice Sotomayor, by contrast, says that is not what Brown versus Board of Education was about, and that recharacterization is revisionist history. If anyone understands Brown versus Board of Education and what it was meant to do and signify moving forward, it was Justice Thurgood Marshall. Before he became a justice on the Supreme Court, he was the chief architect of the litigation strategy by the NAACP when they were bringing the Brown litigation. And she says, pointing to his participation in the Bakke decision, that UC Davis med school decision I mentioned, that he viewed consideration of race as a permissible and beneficial means for remedying racial inequality in society, and that it's his vision that we should pay attention to. Okay, what about the educational benefits of diversity? So this falls out of the picture, largely, in the Harvard and UNC cases. It was okay for UT, it was okay for Michigan Law School, but it's not okay here, and in the chief's opinion, he calls the justifications inescapably imponderable. They're just so vague and amorphous that we can't even begin to assess them. They don't comply with this notion of a colorblind constitution and what we demand for consideration of race. For Justice Thomas and Justice Jackson, I mentioned, this is competing interpretations of history, of what the 14th Amendment was meant to be. And Justice Thomas says he's writing an originalist defense. She says our country has never been colorblind. Justice Thomas says that she has never gotten over history, and as she sees things, we are all inexorably trapped in a fundamentally racist society we can never get past. And she says, I don't know what he's talking about because that's not my dissent. That is my mic that I just hit. That's not my dissent, and that is not what UNC does. And instead, it's just a recognition that race can be a factor that affects applicants' unique life experiences. This is a sketch of the oral argument, the actual argument that happened in the UNC case. You can see her on the right-hand side, and you have the advocate there who represented the students or prospective applicants challenging the policies at UNC and Harvard. And she asked a question about two similarly situated but slightly different applicants with different family backgrounds, different races, and how a policy that prohibits the consideration of race would allow them to both be able to express their feelings about their family history. And I am going to go ahead and play you a clip that's going to take us a little bit past my time. I've been told that that is going to be okay, so bear with me, because I think it's important for you to hear her voice. It was an important voice in this case. It had a huge impact on the way the decision actually came out, and I'm going to go ahead and have you listen.
The first applicant says, I'm from North Carolina. My family has been in this area for generations, since before the Civil War, and I would like you to know that I will be the 5th generation to graduate from the University of North Carolina. I now have that opportunity to do that, and given my family background, it's important to me that I get to attend this university. I want to honor my family's legacy by going to this school. The second applicant says, I'm from North Carolina. My family's been in this area for generations, since before the Civil War, but they were slaves and never had a chance to attend this venerable institution. As an African American, I now have that opportunity, and given my family background, it's important to me to attend this university. I want to honor my family legacy by going to this school. Now, as I understand your no race conscious admissions rule, these two applicants would have a dramatically different opportunity to tell their family stories and to have them count. The first applicant would be able to have his family background considered and valued by the institution as part of its consideration of whether or not to admit him, while the second one wouldn't be able to, because his story is in many ways bound up with his race and with the race of his ancestor.
So the advocate had no good response to her question, and the majority had to make an exception from its colorblind constitution approach to the use of race in admissions and said, nothing in our opinion means that someone, basically an individual, can't write about their own experiences and how race has affected them. And so that is where we are left today, with universities and their admissions policies trying to align with the court's opinion and trying to figure out what it means to allow applicants a chance to express their identities and how their identities may have been influenced by race.
Thank you, Professor Eskow. That was a brilliant presentation. Our final speaker this evening is Dr. Liliana Garces. Dr. Garces is a professor in the Department of Educational Leadership and Policy in the College of Education, as well as an affiliate faculty at UT Law and in the Center for Mexican American Studies within the College of Liberal Arts. Dr. Garces has represented the education community in the filing of legal briefs in the U.S. Supreme Court cases that have played consequential roles in interpreting law around race-conscious policies in education, including Fisher versus University of Texas 1 in 2013 and Fisher versus University of Texas 2 in 2016. Most recently, she served as counsel and co-authored an amicus brief filed by 1,241 social scientists in support of Harvard's defense of its race-conscious admissions policy in Students for Fair Admissions versus Harvard. Welcome, Dr. Garces.
Buenas noches. It is such an honor to be with you here tonight. I'm going to start by addressing the current students in the room. So about 30 years ago, I got into my 15-year-old Toyota Corolla, and I drove from Seattle, Washington, to Providence, Rhode Island, to head to college. I was first generation everything. Formerly undocumented student, on my way to one of the oldest institutions in the United States. My mom and I immigrated from Colombia, South America, about 7 years before. And in that search for educational opportunities for me, she sacrificed so much. And I carried the weight of those sacrifices with me and their inspiration throughout the 5-day drive in my 4 years in college. Now, about a few weeks ago, maybe you boarded a plane, or you got into your Toyota Corolla, or maybe a really nice car with air conditioning, which mine did not have. Maybe you came with your whole family. Maybe you came with your mom or your dad. Or maybe you came by yourself. Maybe you are the first in your family to come to UT. Or maybe you come from a long line of Longhorns. Whatever the case might be, whether you're coming from the West Coast, West Virginia, West Texas, Westlake, East Austin, my message to you is that you belong. You belong. Why am I starting a lecture on the state of affirmative action with these words? I begin by reassuring you that you belong because that feeling of belonging, that what you've accomplished so far demonstrates the great potential that you have to contribute to this community, to society, to the world, and that someone was able to recognize that in you when they extended an offer of admission. That is what's at stake with the affirmative action today. Now, let's begin with definitions. Affirmative action. What is this concept? We know that it triggers so many feelings for so many Americans. People feel so divided about it as a policy. And yet, with all the debate, there's so much confusion about what it is and what it's not. And we heard a great historical account from Dr. Joseph. I will take us to the 1970s. My research is actually focused on understanding how legal cases have come to shape the practice to what it has become today. And in the 1970s is when legal cases began to really shape the practice. At that time, you had the Bakke case, which has been mentioned a couple of times. And in that case, you had 5 justices who, well, let me back up. In the 1970s, the way that affirmative action was practiced was colleges and universities would set aside a certain number of spots for historically excluded populations in order to level the playing field so that we could address the history of racial exclusion from institutions for Black students, for Latinos, for Asian Americans, for Native Americans, for Pacific Islanders. And then you had the case Bakke. And Bakke said you had 5 justices who read the Equal Protection Clause to say that these set-aside programs, what you've also probably heard referred to as quotas, were not allowed. That colleges could not justify using race explicitly in their policies in order to address historical wrongs or societal discrimination. That colleges could use race explicitly if it was one of many factors and as long as the rationale for it was based on diversity in the student body. And so after Bakke, you had colleges and universities change their practices. No more quotas, no more set-asides. Only policies that would be more, I think, accurately described as race-conscious admissions, where race was considered along a number of other factors like high school GPA, standardized test scores, extracurricular activities, in order to help build and admit a racially and ethnically diverse student body. But the controversy over the policy continued, and the issue goes back to the Supreme Court 2 other times, not counting this most recent one. In 2003, with the cases against Michigan, and then in 2012, 2016, with the case against UT Austin. And in each case, the court says that race-conscious admissions is permissible, that institutions can use it because it furthers their institutional mission. Now, by the time that these cases had come before the court, there was a robust body of social science research documenting the many benefits of racially and ethnically diverse student bodies, benefits for education and society. Research showing that it helps improve critical thinking skills, that it helps dispel racial stereotypes, that it improves leadership training, that it leads to more innovative approaches to some of the most complex problems in our society. And the research also showed that it wasn't that these benefits don't just happen on their own, that they require all students to feel a sense of belonging, especially for those who are from populations that have been historically excluded. Now, when I was driving my Toyota Corolla to Providence without air conditioning, I did not know about any of this research. I remember feeling excited about the possibility that I would get to meet students with very different experiences than mine. I remember wondering if I would meet other Latinas with a similar immigrant journey as mine, so that I could feel a sense of belonging in that new context. And throughout my 4 years in college, I came to realize that my educational experience, in fact, was richer. From having experiences and discussions in the classroom with others who had very different perspectives than mine, in part because they had different racial and ethnic backgrounds. I came to really value the Latino organizations because they helped me feel a sense of belonging, of community, a place where I could recharge as a Latina in a predominantly white campus. I had professors who shared my ethnic background for the very first time in my educational experience in the United States, who helped me see that I too could become a faculty member, who felt deeply invested in helping me with my aspiration to go to law school. And by the end of those 4 years, my Toyota Corolla had died on a side of a steep hill in Providence, but my main point is that my education was richer. Society was richer, with one more Latina who would get to go on to law school, one more lawyer who would advocate for the rights of other immigrants before the US Supreme Court, and one more Latina who would join the faculty ranks and eventually come and teach at UT. And these outcomes were possible because the legal cases gave colleges and universities the tools they needed to help admit a racially and ethnically diverse student body. Now, my comments so far take us to the state of the law as of 2.5 months ago, and Professor Eskow provided a wonderful overview of a very rich decision. And what I will contribute is that this debate about affirmative action really is a much larger debate about how, as a society, do we help ensure equal treatment and opportunity in a racially divided society? And that interaction between Justice Jackson and Justice Thomas represents that question. And there's two perspectives. There's one perspective, also held by those who have brought these legal challenges to shape the practice to what it has become today, is that we need to stop racial classifications in our laws, our policies, and our practices. That if we stop racial classifications, we will end racial discrimination. That if we do not name race explicitly in our policies, race will stop mattering. Now, there's a second perspective, the perspective that to ensure equal protection and opportunity, we need to speak openly and candidly about race, to use words that Justice Sotomayor wrote in an opinion. That we need to explicitly consider it in our policies in order to understand how racism shapes opportunities and experiences. That when we don't, we actually make matters worse. And there is a robust body of research documenting what happens when we're not able to consider explicitly race in our educational policies. And I have contributed to that body of work throughout my entire academic career. And what we know is that when we are not able to consider race, when we prohibit race-conscious admissions, the representation of students of color significantly declines across a number of educational sectors, at selective institutions, in graduate studies, in fields of medicine, in law schools, and business schools. And what we also know is that in the aftermath of these policies that prohibit race-conscious admissions, administrators feel as if they can't even talk about race or racism. And that is in the context where the laws don't even apply. Outside admissions, like in student support programs, where these discussions are so critical to helping dispel the racial stereotypes that so many of us hold without even realizing it. And what this body of research shows is that it supports the second perspective, that we exacerbate racial inequality when we don't explicitly consider race in our educational policies. And what the court's most recent decision has done is place us closer to that first perspective, setting aside the lessons of research in almost 50 years of precedent. So I will conclude, since I am at time, with just circling back to this question: how do we promote equal treatment and opportunity in a racially unequal society? Obviously, too big a question for us to address in our short time together. But for all of you students, it does begin with the meaningful interactions that you'll be able to have in these coming years before you. Interactions across race, ethnicity, socioeconomic background, sexual orientation, gender identity and expression, political perspective, religion. Interactions that can challenge your worldview, your perspective. But for those interactions to be meaningful, we all need to feel a sense of belonging. And you can help create that for each other, but it is not your task alone. It is for us as faculty, as administrators, to help create the conditions that help you all feel that you belong. Thank you.
Dr. Garces, thank you so much for your comments. Please stay seated and join me in giving another round of applause to all three of our speakers tonight. Yes. I think we have time for one and maybe two questions. So the first question has come through, and I think Professor Eskow, Dr. Garces, either one of you can take this or you can both contribute. The question is, how would you describe the cultural impact of Fisher versus the University of Texas, not only on the UT campus, but in other college campuses?
Well, I was not here at the time that the Fisher case was being litigated. I was early in my academic career, and I was working with social scientists who were trying to translate the lessons from social science research and how it fit with the court's decision and the legal framework, and to help really inform those deliberations so that they would be grounded in empirical realities. And it was, I think, a surprise to many that the first time the case went to the Supreme Court, it got sent back to the lower court in order to determine if the parameters of the precedent in the cases had been followed. And the lower court said, yes, they were followed. It goes back to the Supreme Court, and you have an outcome that nobody anticipated. And in that outcome, the court continues to endorse race-conscious admissions as constitutionally permissible because of that end goal of having a racially and ethnically diverse student body that helped improve the educational experience and actually was connected to the institution's mission. So that's my answer to that question.
Yeah, I think that's an excellent assessment of the situation. The only thing I would add is that I think there was that surprise factor, and I think also one thing that really wasn't questioned at the time so much was that the educational benefits of diversity, that was something legitimate to consider. What was questioned more was how narrowly tailored the program was, like was race-conscious admissions to fill the extra spots after the top 10% really necessary to meet the goal. But nobody really questioned the goal. And now I think we have a real upending of the goal as being viewed as something credible, legitimate, and the colorblind Constitution approach doesn't really permit consideration of that goal directly in admissions.
Well, in that case, I'm going to ask you one more question, because we have a little bit of time. It'll be brief, but nevertheless, one question has come through, which is, how do you think affirmative action can be balanced with a meritocracy-based system?
What an excellent question. It goes at the heart of the questions around affirmative action. What is meritorious? How do we define merit? Do we define it on a very individual basis, grounded on metrics that might disproportionately measure different things than what we're looking for? right? Like standardized test scores, which are so highly correlated with family wealth and not so much potential? Or can we ground it in measures that are more community-based, more democratically based, related to the values that a student brings that would contribute to a multiracial democracy? I think if we did the latter, then they are compatible.
I would just say also that I don't think there's a tension between the two concepts. I think that the holistic approaches by Harvard and UNC, to me personally, seemed to reflect meritocracy in every way, and that acknowledging that race plays a role in certain people's lives isn't, in my opinion, turning your back on meritocracy. I think it's part of a meritocratic approach to admissions.
Thank you both so much. I think this conversation and what you've sort of shared with our group, and also Dr. Joseph, has given our students lots to think about and discuss in your UGS courses, but also, as you said, throughout their college careers. Very thankful and grateful for you being here. So, students, just want to say to you, thank you all for making the time to come out here. I understand this weekend might have been a little busy for some of you, but I'm glad you made it here tonight. Very good to see you all. Thank you for coming, and once again, thank you so much for contributing to our intellectual discourse on campus. Thank you and good night.